gentlemen of the media, and those who are listening to this broadcast. I've invited you here this afternoon to talk about an Act of Parliament which was recently passed in the House of Representatives and in the Senate. This act was assented to by the President, but it is not yet proclaimed as being operated as law in Trinidad and Tobago. The name of the act is the Criminal Division and District Criminal and Traffic Courts Act 2018, Act number 12 of 2018. The Act in Section 2 specifies that it would come into operation on a date to be fixed by the President by proclamation. The Act on its face would give the impression to the public that all that was happening by the Act was that Parliament was creating a new court, and therefore the public would think on its face that the Act was an effort to improve the administration of justice. If one takes a deeper look, however, at the Act, it will be seen that the Act takes away a significant and fundamental part of the jurisdiction of existing magistrates, and consequently, it made fundamental changes to the terms and conditions of existing magistrates' contracts of employment. The action taken by the Parliament to create a new position for a judicial officer to be appointed to that office to do the work of existing magistrates must be of great concern to anyone who believes in the rule of law and the independence and security of the tenure of the judiciary. This was an attack on the existing magistrates who constitute part of the lower judiciary of Trinidad and Tobago. The Parliament altered the terms and conditions of employment of magistrates with the state. By the terms of the Act, the Parliament took away part of the core jurisdiction of existing magistrates without consulting with them and without getting their consent, and gave it to masters of the criminal court. This is unacceptable. It is a serious precedent, and therefore it must be redressed. Would Parliament in the future, using this precedent, be able to take away the jurisdiction of the High Court or the Court of Appeal by creating other positions and having those positions filled by other judicial officers, and give to those judicial officers the functions and duties of the judges of the High Court and/or the functions and duties of the judges of the Court of Appeal? This would not be constitutional, and if it is not constitutional for the upper judiciary, it cannot be constitutional for the lower judiciary. The issue, therefore, concerning this Act of Parliament involves the independence of the judiciary and the subversion of the Constitution of Trinidad and Tobago and the rule of law. The government must therefore reconsider the provisions of this Act. The Parliament must also reconsider the provisions of this Act. This Act must not become operational, and steps must be taken for this Act not to be proclaimed and not to become operational. The role of lawyers in a society. From the time I became a lawyer, I always believed that the legal profession and individual lawyers have a commitment to promote and preserve the public good. Lawyers have an interest in promoting the advancement of society. Lawyers should not only be concerned with a legal industry in which lawyers operate businesses in the law. Lawyers are something more than service providers. Lawyers have a bargain with society in which they promise conscientiously to serve the public interest, even if to do so at times may be at their own expense. Lawyers have a duty to be outspoken on matters affecting the public interest, especially where these matters concern the administration of justice or the governance of the country. I have had my time in public office, and as I've said before, I am no longer interested in seeking public office, political or otherwise. However, I believe I have a duty to society to use some of my experience and knowledge as a lawyer to point out to the public when I see fundamental wrongs occurring which are threats to important or basic principles of the Constitution or of governance. I have in the past, when I see measures, especially where they have an adverse impact on human rights, the rule of law, the independence of the judiciary, and poor governance, made statements for the public to better understand the issues and to better understand their rights of citizenship. Lawyers have a role in the public education of society by explaining to the public the impact of legislation or governmental action on the enjoyment of fundamental and human rights or the rule of law. It is in that context I am here this afternoon to talk to you, and through you, the members of the media, to the people of Trinidad and Tobago about an act of parliament which, if implemented, would not only be an attack and an injustice to members of the lower judiciary of Trinidad and Tobago, namely the magistrates, it would be an attack which can have adverse impact on the independence of judicial officers, the rule of law, and the doctrine of the separation of powers, which are basic features of the Constitution of the Republic of Trinidad and Tobago. It is my opinion that when an important institution like the lower judiciary is attacked, either indirectly or directly by any arm of the state, that is the legislative arm, the judicial arm, or the executive arm, members of the legal profession have a duty to make the public aware of the adverse consequences such acts can have on the enjoyment of fundamental rights in the country. It is in this context I congratulate the President of the Law Association, Mr. Douglas Mendez, Senior Counsel, and the Council of the Law Association for the work it has been doing in bringing to the attention of the public its concern about the passage of legislation without proper consultation with the public and the legal profession. This is one of the several pieces of legislation which the Law Association and its president have expressed concerns about. Duties and functions of magistrates. Since Act number 12 of 2018 directly impact upon the existing magistrates, it is important for me first to give you some information about the duties and functions of magistrates. Before I give you those duties and functions, I want to explain to you what are summary matters, what are indictable matters, and what are hybrid offenses, because you would have to understand what I mean when I refer to those terms in this statement. There is a difference between summary cases and indictable cases. A summary case is a case which is related to not so serious a criminal offense, and an indictable case is a case which involves a more serious criminal offense or a very serious criminal offense. The existing magistrates deal with both summary cases and indictable cases. In a summary case heard by a magistrate, the magistrate can determine if the accused person is guilty or not. In an indictable case heard by a magistrate, the magistrate cannot determine the guilt of the accused. That is determined by a judge and jury if the magistrate determines that there is sufficient case to be tried before a judge and jury. If the magistrate determines that there is not a sufficient case to be tried before a judge and jury, the magistrate discharges the accused. The inquiry which the magistrate conducts to determine whether an accused person should be discharged in an indictable case or committed to stand trial before the High Court is known as a preliminary inquiry. A hybrid offense is an indictable matter, which is a serious criminal matter, which, by the agreement of the prosecutor and the accused, the magistrate can do it like a summary matter and determine if the accused person is guilty or not guilty. I would now deal with the duties and functions of magistrates. They are judicial officers, engage in 100% of all criminal matters initiated in the magistrates' court involving adults. Prior to the functioning of the juvenile courts earlier this year, all criminal matters in which both juveniles and adults were charged were initiated in the magistrates' court. The magistrates' court exercised original jurisdiction in relation to summary matters, including criminal matters, inquests, domestic violence matters, detention and forfeiture of monies, child custody, maintenance matters, access to children, adoption matters, private complaints against individuals, ejection matters, the granting of liquor and other licenses, drug treatment courts, etc. They also do traffic matters. Magistrates also adjudicate in hybrid offenses where it is recommended that an indictable criminal matter, which is a serious criminal matter, and which ordinarily would be done by a judge and jury in the High Court, can be done in the Magistrate Court. Such hybrid offenses would include illegal drug possession, illegal drug trafficking, fraud, some sexual offenses, possession of arms and ammunition, robbery with violence, robbery with aggravation, and larceny. Magistrates also hear and determine preliminary inquiries into indictable criminal offenses. Those are serious criminal offenses. Magistrates determine whether a case has been made out against an accused person for it to be tried in the High Court before a judge and jury. Based on the decision made by the magistrate that a case has been made out, the DPP, who is the Director of Public Prosecutions, then indicts the accused person if the DPP agrees with the decision of the magistrate that the accused person should stand trial at the High Court before a judge and jury. Magistrates also have jurisdiction to sit in the magistrate's court as a petty civil court judge to deal with civil matters involving civil claims up to $50,000. Magistrates are also engaged in dispute resolution pursuant to trials they have before them, restorative justice dialogues, and mediation. It would be readily seen, therefore, that magistrates directly and indirectly have an impact on the lives of almost every individual in Trinidad and Tobago. They perform an important function in the administration of justice. Anyone directly or indirectly connected to an individual who has to appear in the magistrate court would be affected in some way or another by what happens to that individual. Sorry. The effect of the Act. I told you that the Act, when one looks at it deeper, it would be seen that the Act takes away a significant part of the jurisdiction of existing magistrates. The core criminal jurisdiction of existing magistrate is its jurisdiction to determine preliminary inquiries, that is to determine whether persons charged with serious criminal offenses ought to be tried by a judge and jury. This is part of the core jurisdiction of magistrates. This process involves the magistrate listening to all the evidence, examining the cross-examination of the witnesses, and in some cases examining the evidence of the accused person and his witnesses, and then to determine whether there is sufficient evidence to go before a jury. If there is sufficient evidence to go before the jury, the magistrate commits the person to stand trial before a jury. In determining a preliminary inquiry, the magistrate has to consider the principles of law relating to the relevance of evidence, the elements of the offense, the admissibility of evidence, the probative value of evidence, and whether in law a case has been made out against the accused for the accused to stand trial for the offense. Section 9 of Act number 12 of 2018, which is the Act which I am talking about, expressly states that a criminal court master would have all the powers exercisable by a magistrate in criminal matters, A, under the Summary Courts Act, including the power to hear indictable matters summarily, and B, under any other written law. A criminal court master, therefore, is therefore a new position created in the High Court by the Act for such a master to take over those important functions and duties of magistrates. And those are the functions and duties mentioned in Section 9 of the Act, which are the functions exercisable by a magistrate in criminal matters under the Summary Courts Act, including the power to hear indictable matters summarily, and if you recall, are hybrid offenses and any other written law. The effect of Section 9 of the Act, therefore, is that all of the criminal matters which existing magistrates at present have jurisdiction to hear and determine under the Summary Courts Act, including the existing magistrate's jurisdiction to hear indictable matters which are agreed by the prosecution and defense to be heard summarily. That is, to determine whether the accused person is guilty or not, would under this Act no longer be heard by existing magistrate, but when the Act commences in operation as law in Trinidad and Tobago, it would be heard by a criminal court master. The effect of the Act, therefore, is that all preliminary inquiries, that is, all indictable matters, in which existing magistrate now determine whether there is sufficient evidence for the person to face trial before a judge and jury, would also be done by a criminal court master, because Section 9 talks about any other written law, and that written law would mean that which is being done by in a preliminary inquiry, because the government can institute legislation to deal with preliminary inquiries, which it intends to do in a short space of time. It follows, therefore, that a substantial part of the jurisdiction of existing magistrates are to be taken away from existing magistrates and given to the criminal court masters. These criminal court masters would be new appointees appointed in the High Court as masters to take over the jurisdiction of existing magistrates. I am sure some of you would be asking the question, when this Act comes into full force, what would be the jurisdiction of existing magistrates? These existing magistrates would, under the Act, be sitting in a court to be known as the District Criminal and Traffic Court. The new jurisdiction of the existing magistrates would therefore be traffic cases. Section 12 specifies that this District Criminal and Traffic Court would be a summary court, and its jurisdiction in criminal matters would be limited to matters which are to be dealt with summarily or a traffic violation. The existing magistrates, therefore, would be sitting in a court with a big name. That court under the Act is to be known as the District Criminal and Traffic Court, but the magistrate would be known as district judges, also a big name, but would have a limited jurisdiction to do petty criminal matters, petty civil matters, and traffic cases. The result is, therefore, that the core and important jurisdiction of existing magistrate, which I have spoken about above, would all be taken away and would go to criminal court masters. The existing magistrate would remain with a small and insignificant jurisdiction, but would be functioning with a big name called a district judge. The existing magistrate would in effect be doing traffic cases and ticket cases which flow from the traffic cases. It is important to note that the Act makes no provision for the existing magistrates to be automatically appointed as criminal court masters to continue to have the jurisdiction which they exercise as existing magistrates. The existing magistrates by the Act would have to apply to be appointed to the position of criminal court masters for them to get the job that they already had of hearing and determine preliminary inquiries, hearing and determine hybrid offenses, and other matters which the criminal court masters would take over. The Act also does not provide that if the existing magistrates applied to be High Court masters, in order to exercise that jurisdiction, their application for such an appointment would be given primary consideration. The public is also aware that the government has agreed on a policy to abolish preliminary inquiries. If abolished, a court would no longer have to determine whether there is sufficient evidence for an accused person to face trial before a judge and jury of the High Court. If preliminary inquiries are abolished, it would mean that the present composition of judges in the High Court and masters of the High Court would not be able to deal with the workload of criminal trials which go to the High Court. This would mean that in cases in which you now have to have a preliminary inquiry in the magistrate's court, 90% of those cases are likely to go directly to the High Court instead of those cases going to a magistrate or to a criminal master to determine whether there is sufficient evidence to go for trial. The existing magistrates who have had years of experience of assessing and dealing with the evidence at preliminary inquiries, and who would have had the experience in dealing with the principles of law which are relevant for evidence to be adduced to determine whether there is sufficient evidence to face trial, would be suitable and appropriate persons to be criminal court masters to handle such workload if preliminary inquiries are abolished. It is perplexing and curious to understand the policy contained in this act for existing magistrates not to move directly from the magistracy into the position of criminal court masters in order to deal with the workload of criminal cases, having regard to the years of experience they have gained in dealing with these matters. Improvements in the magistracy. The existing magistrates in all the magistrates' courts in Trinidad and Tobago have done a great service in Trinidad and Tobago in that the records of the magistrates' court show that matters generally are determined in the magistrates' court in a timely manner. The system is not perfect, as there is a lot of room for improvement, but it has to be recognized that there have been improvements in the magistracy in recent years. The use of paper committers in preliminary inquiries, paper trials in summary matters, case management tools, magistrates sitting for longer periods, and the use of audio recording systems have all contributed significantly to clearing some of the backlog at the magistrates' court. The annual report on the statistics of the magistrates' court show the volume of matters completed by each magistrate in the magistrates' court. Conditions of work of magistrates. Magistrates show a commitment to dispense justice in a timely manner, although they sit in mornings and afternoons. This never used to be the position. Magistrates used to only sit on mornings, generally. They sit in poor working conditions, dilapidated courtrooms, most of which are not purpose-built, and often offer poor lighting, no air conditioning, and poor ventilation. With very little resources to work with paper shortages, etc., in managing very large caseload with insufficient support staff, and with external factors over which magistrates have no control, such as availability of both defense and state attorneys in the magistrate court where they involve in trials in the High Court, delays emanating from the police armory and from the Forensic Science Center, and also the police service, with high security risk, with no immunity from personal responsibility for decisions made by magistrates. Injustice to existing magistrates. The reduction in the jurisdiction of existing magistrates would obviously involve a loss to existing magistrates of job satisfaction. It is reasonable to conclude that magistrates enter the magistracy with the expectation that their jobs would not only entail traffic cases and ticket matters or petty summary cases and petty civil matters under the Summary Courts Act, but their job would involve them in professionally assessing principles of law and applying them to the facts of cases. This would result in their mental and intellectual stimulation. They would enjoy job satisfaction in keeping abreast with principles of law and applying them to summary and indictable matters. They would be involved in the development of the law and the jurisprudence of the country. Magistrates did not enter the magistracy with the expectation of determining traffic matters, ticket matters, and obscene language matters every day or most days of the week. The loss of job satisfaction to magistrate is enormous. It cannot be overstated, and this is a serious matter. Judicial officers cannot be allowed to lose their jurisdiction overnight by members of parliament voting in the parliament on a bill, taking away their court jurisdiction. This is a serious attack on the independence of judicial officers, their security of tenure. The Parliament, by exercising a vote to pass this bill, has in effect de-skilled the existing magistrates, in that they have represented to the public by their decision that these existing magistrates who have discharged their duties and responsibilities to the nation ought not to be chosen automatically to continue as criminal court masters under the Act to perform the same functions which the magistrates have been performing over the years. It must be disheartening for existing magistrates to have to apply for the position of masters of the criminal court to adjudicate in matters which they currently adjudicate in the magistrates' court and which they have been doing for a considerable number of years. The issue, therefore, is not whether or not there should be criminal court masters. I have not done a study, and no study has been presented to the public to justify the creation of these new posts of criminal court masters. The question is, if we are going to have criminal court masters to perform the jurisdiction of the existing magistrates, why the existing magistrates are not automatically transferred to the post of criminal court masters to perform the same functions and duties which they have been performing and which they are now performing, or which they perform substantially the same duties. If this is done, it would provide the existing magistrates with the attraction of upward mobility in the judiciary without ignoring the years invested in the service and the competence and service they provided as the existing magistrates in the performance of their duties. Further, the Act recognizes in Section 9 that the criminal court masters would be given all the powers exercisable by existing magistrates in criminal matters under the Summary Courts Act, including the power to hear indictable offences summarily and under any other written law. The Act therefore confers on masters of the criminal court the same powers of existing magistrate, but the remuneration package offered to masters of the criminal court is higher than the remuneration package of existing magistrates. The question to be asked is, why magistrates who have for many years made representations to the Salaries Review Commission for improved terms and conditions based on the volume of cases and matters done by them and the jurisdiction exercised by them in the magistrates' court, were unsuccessful in getting their representations accepted. But masters of the criminal court, who are now vested with the same powers and jurisdiction of existing magistrates, are now being given a more attractive compensation package than existing magistrates to perform basically the same duties and functions which existing magistrates have performed and are performing. What is the purpose for this? The country deserves to get answers and get the reasons. The administrative arm of the judiciary is accountable to the public. The public therefore must be told why is it necessary to create this new position, to appoint new persons to fill these positions, instead of the existing magistrates being placed in this position to perform the functions and duties as criminal court masters when they have been doing these functions and they continue to do these functions or substantially the same functions which criminal masters would perform. Research given to me informs me that recently in Jamaica, by Act No. 6 of 2016, the Jamaican Parliament enacted legislation for resident magistrates in Jamaica to perform the functions of judges of parish courts, and it provided for the existing magistrates to perform those functions with better terms and conditions. The parish courts are performing the functions which existing magistrates in Jamaica perform. It would seem to me that that is only logical and fair for the state to take steps to ensure that existing magistrates are absorbed in the position of criminal court masters so that the country can get the maximum benefit of their previous service as existing magistrates and a grave miscarriage of justice can then be avoided. Constructive dismissal. If an employer takes away the core functions and duties of an employee and places that employee to do inferior duties in comparison with the duties which the employee was employed to do, that would constitute a breach of a fundamental term of the contract of employment of the employee. that would be regarded as constructive dismissal of the employee, because such a breach would go to the root of the contract of employment. An employer is not permitted to change the duties of employees under a contract of employment in such a way as to change the duties to make that employee do inferior duties in comparison with the duties which the employee was contracted to perform when the employee was employed. In such circumstances, an employee who faces this treatment from an employer can take the position that the employer has constructively dismissed him or her without actually dismissing him, and can claim damages from that employer. In substance, what the Parliament has done, without consultation or consent of the existing magistrates, the Parliament have altered the terms and conditions of the contracts of employment of existing magistrates in making fundamental changes to the duties which the magistrates were contracted to perform. The Parliament, by the terms of the Act, decided that existing magistrates would perform inferior duties to the duties which they were contracted to perform. Parliament has in effect taken action which can be regarded as being akin to constructive dismissal. It is a serious matter if Parliament, arbitrarily without the consent of judicial officers, take action which is akin to constructive dismissal of existing magistrate. It violates the principles of the rule of law, the doctrine of the separation of powers, the independence of the judiciary, the security of tenure of judicial officers, and it subverts and undermines the Constitution of the Republic of Trinidad and Tobago. What Parliament has done is not merely an injustice to existing magistrates, because the injustice to these judicial officers of the state is an injustice to the entire judiciary of Trinidad and Tobago. It is an injustice to the people of Trinidad and Tobago. It is an injustice to the legal profession, and it amounts to a contempt for the basic principles of our Constitution, which includes the rule of law, and it subverts the Constitution. I therefore call upon the government to take the necessary action to ensure that this Act is not proclaimed to operate as law in Trinidad and Tobago unless it is reconsidered by the Parliament and the government, and that the injustice which is threatened to be done to existing magistrates are therefore redressed. Thank you very much. I would invite questions from anyone.
Given the size of the magistracy and what they're being relegated to do, doesn't too many magistrates for what they're proposed to do now. So does it mean that there could be restructuring and retrenchment in the judiciary?
Well, assuming that the judiciary has to appoint criminal masters of the High Court to do all these criminal cases which were being done by magistrates, you raise a very important question, because there will be no space. The existing courts, magistrates' courts, may have to be converted as part of the High Court. And a lot of the magistrates would have very little to do. And I do not know if you know, but right now there are complaints from the courts that the courts do not have sufficient place for courts to hear cases, because some of the judges are saying that they cannot hear some of the cases because there is no court available. So the question you have raised is very important. It does not seem as though a lot of planning went into passing such a law, and what would be done if the law is implemented, and what would happen to existing magistrates.
Do you think that it could lead to some sort of retrenchment? I mean, because as I said, there's not enough facilities. Like, for example, what is going on down there?
Well, it would make some of the magistrate positions redundant.
And how many criminal matters? How many traffic matters actually go to court as opposed to people paying a fine or ticket?
Oh yes, if the magistrates merely have to do traffic matters, inquests, and these petty matters that they have to do, it means that you would have too many existing magistrates to perform those duties.
No. Do you know if any consultation was done before this bill was brought to Parliament?
My inquiries have revealed that no consultation was done with the magistrates or with the legal profession. I read a letter that the president of the Law Association wrote to the Chief Justice, to the Attorney General, and it is quite clear that the legal profession was not consulted. My inquiries from members of the Law Association that I've consulted, from their information, the magistracy was not consulted.
So have you had any contact with any magistrates on how they feel about this?
Well, I did not have any contact with magistrates as to how they feel about it, but I was consulted by some magistrates in respect of the legal issues which are involved.
These criminal court masters, will they be sitting separately from the magistrates, or do you have an idea how that works? Is it that
it is stated that the criminal court masters would be part of the High Court, so they will not be sitting as magistrates in the magistrate court. They'll be sitting in the High Court. But in relation to the question which was just asked to me, the High Court would not have enough space to accommodate all these criminal court masters to do all these criminal cases.
Just to clarify, someone is charged with murder. Does it go before the court master before it goes to the judge?
Okay, I could explain that to you.
Yeah.
At the present time, someone charged for murder, that is an indictable case, it goes before the magistrate. The magistrate then determines whether there is a sufficient case to go to trial. If the magistrate determines there is a sufficient case, the person is committed to stand trial. What would happen with the criminal court masters is that the intention is that under the Act, all of the summary cases that I mentioned would be taken away from the magistracy, with the exception of the traffic matters and other matters. There's another bill which is dealing with preliminary inquiries. So the intention is to abolish the preliminary inquiries so that the preliminary inquiries would go straight to the criminal court masters.
For determination.
For determination.
And when the court master determines that, what happens next?
Well, the criminal court masters or the criminal court judge, because in effect there'll be no preliminary inquiries again. So they will determine guilt with a jury.
Okay. So for the summary offences, they will all have...
The summary offences, apart from traffic cases, will be done by criminal court master.
Will it be before the court master alone or a court master and jury?
No.
Or it's based on the offence?
No. A summary case is not done before a jury. So the summary case would be done by a criminal court master.
Okay. But in terms of abolishing preliminary inquiries, do you agree or not agree with it? Because if it is an investigation done by the police, which is sent to the DPP, which is a high-ranking legal practitioner, is it really necessary from the DPP to go to a magistrate and then to a judge?
The issue of whether preliminary inquiries are to be abolished in several jurisdictions have attracted a lot of arguments for and against. There is a strong argument that if you have an investigation done, you do not have to go to a magistrate court to have the evidence rehearsed and then you have it rehearsed again. But there is also the argument that what happens is that sometimes the police can charge someone wrongly, and therefore if you put a person right away to stand trial, there may not be sufficient opportunity for the evidence to be investigated after disclosure in order to establish innocence. So there are arguments for and against. But I think that if there are sufficient safeguards in having trials from the DPP go straight to a judge and jury with sufficient safeguards before the trial occurs, one can see a case for dispensing with preliminary inquiries, especially in a system where you have a lot of delays and demand for important judicial time. But a lot of the indictable cases, a lot of the preliminary inquiries, indictable cases, which are filed indictably, are not done indictably, are not done before a judge and jury. What happens, I would say about half, 50% of those cases are done as summary matters, because if the police and the accused person agrees, or the lawyers agrees for the matter to be done summarily, the magistrate determines the guilt. So the criminal court masters would determine that now if the act becomes operational.
Mr. Maharaj is saying here that the independence of judicial officers are under attack, right? I wanted to find out, the court masters, you're saying that there's no provision to say that the magistrates will now take up those positions. But who's doing the hiring of the court masters? Is it not the judiciary? Can they have? Can they then now control it? Yes, the parliament would have passed the bill, but can the judiciary itself say, well, we're bringing the magistrates up?
I should have made that clear. The parliament is not appointing the court masters. The executive is not appointing them. They are being appointed by the Judicial and Legal Service Commission. And the existing magistrates can apply, but they do not have any primary or any preference of being appointed. So the point I'm making is that if it is that you are going to have magistrates who have been doing this criminal jurisdiction for a very long time, who have experience in it, who have done it before, and you have to make them apply, you're creating a position for new persons to be appointed. And therefore, it seems that it should only be fair, not only to them, but to the country, that these people who have all the resource already in their brain to be able to do the job, as they have done in Jamaica, I'm told, to be automatically transferred as, or promoted or appointed as criminal court masters, if that is the right policy, and for them to be able to do the criminal work.
Do you know what now differentiates the quartermasters from the magistrates, in that, is it that you need to have like a higher degree of training, or?
No, from what I'm seeing and what I understand, it's lawyer, some years in as a magistrate or as a lawyer, and that's it, experience. There's no special training to be a court master. As a matter of fact, the court master, the criminal court master, would be doing the same work that a magistrate did over the years in, for example, treating an indictable matter as a summary matter. Let's say that one is charged for larceny, and that matter is to be done indictably. And when it goes to the magistrate court, the matter is agreed to be done summarily. The magistrate determines the guilt. The criminal court master would be doing the same thing with such a matter. So it's the same or substantially the same function where the criminal court master would be doing that the existing magistrates are now doing. If you, however, abolish preliminary inquiries, the only difference would be that the magistrate would be listening to the evidence as a criminal court master. The magistrate would be determining whether there's a sufficient case to go to the jury, just as the magistrate determines now, and the criminal court master would have to determine that, because if there's no sufficient case, just as the magistrate throw out the case, the criminal court master would have to throw the case if the magistrate sits as a court master. The criminal court master would not determine the guilt of such an accused. The criminal court master would have to let the jury determine the guilt. And what the criminal court master would have to do, what the judge does now, direct the jury by summarizing the evidence and by giving them the principles of the law. And that is exactly what the magistrate does now if they have to determine a case is made out or not.
And just to be clear, by saying you want Parliament to reconsider this, you mean you want them to just not have this position of a criminal court master?
No, 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 no. I am not in a position to say whether the position of criminal court master is a good thing or a bad thing. What I'm saying, because I haven't gone into that, what I'm saying is that if the criminal court master is being created as a new position, and they would end up, and a criminal court master will end up doing the same or substantially the same work as an existing magistrate, why you are bringing in new people to do that work, and you're going to make existing magistrates redundant, and you're going to create a problem in the magistracy and in the judiciary. So it has to be, the reason has to be given to the public and to the legal profession why it is, because the impression can be given is that this is a law deliberately put in this way to make existing magistrate redundant. And that is an attack on the judiciary.
So, for small offences like small possession of marijuana and common assault and those type of things, the court master is going to handle that as well?
Yes, that will go to criminal court masters. Because what I read to you in Section 9, they will be doing all the summary matters, with the exception of traffic violation. So all the summary matters, whether it is possession of marijuana, whether it is a simple larceny, any offense that you can think about, any summary matter. So the magistrate, the existing magistrates, would be basically a traffic court. In substance, that is what it's going to be.
But aren't most traffic offences ticketable, or you just go pay a fine or something?
Correct, correct.
So you're going to... How many magistrates, or almost every magistrate, to oversee?
And that is why I've become very concerned about this, because what you are doing is that you're creating a serious precedent. Now, I don't know if the public understand this, but just give me an opportunity to. When Trinidad and Tobago was getting independence, one of the things that the politicians of the day fought hard for was that the judiciary should be independent. And that is why there are safeguards in the appointment of judges and magistrates. Now, if you have a precedent in this country where the parliament can pass a law and create new positions and allow those new positions to take over the jurisdiction of judges, whether in the High Court, Magistrate, or Court of Appeal, it is a serious matter because it can affect the independence of the judiciary, because you'll be constructively taking away or dismissing judges and judicial officers. And that is why this is a serious precedent, and we should not allow it to go without condemnation and without fight. I have had serious thought of this, and I decided that I come public on it. As you know, I've been silent for a long time, but I've decided to come public on it. I have been engaged with my law practice, but I've decided to come public on this.
Let me just ask one last thing. You don't think this is similar to what is being done at Fetterton, where new positions, a new function is being created, where for and people are going to be working in the same positions.
But it's a bit different because these are judicial officers, and judicial officers enjoy a special role. I don't want to get involved in the Petrotrin issue because I would prefer to leave that at this stage for the union. But as one who was engaged in the Carney workers' struggle, anytime that a government is sending home that number of people, it is a decision which has to be carefully studied. A lot of work has to go into the impact of the families who would suffer. And it has to be done in a way in which it would appear to be fair and human beings would not suffer. I do not like how it was done. I do not know all the facts, but I think that as someone who has been in public life, I would have difficulty sending home such number of people within a short space of time, and to just think of the human suffering that would occur in the families of Trinidad and Tobago. I know one has to balance that with economic considerations, but I mean, if I were in public office and I had the authority, that is something I would not do in the way it was done.
So what you're basically saying is that a more logical approach would be to promote the existing magistrates to court masters and then hire new members to work on the traffic court.
Yes, but you got it. You got it. In effect, what I'm saying is that since these existing magistrates can perform the function of the functions of the criminal court masters, you absorb them, you promote them, you appoint them, you transfer them, whatever it is. But you may not have to appoint anyone in the magistrates court because, from what I understand, there is really not much jurisdiction in traffic court matters because of the ticket system. And if you have to appoint, you appoint some to do, some others to do the traffic court jurisdiction. But if criminal court masters are going to do summary matters, they can also do traffic matters. But I must confess, I do not understand the logic of this law. I do not understand the logic of taking that jurisdiction and taking it to the High Court. And just in namesake and calling people different names. I don't understand it.
But it's just because it's not just going to affect the magistrates. What about the people who work in that department, in those departments? Is it going to affect those people also?
Well, it may be they would transfer some of those people to the High Court and allow them to become involved in the administration.
Like the Petrotrins, you lose their jobs and now have to reapply for positions that they already do.
Well, the public servants cannot lose their job like that because the public servants are not like employees of Petrotrin. The public servants, officers, their terms and conditions are protected by statute, and there's a special means whereby they will have to do that.
What you're saying is that the magistrates' positions would be sort of redundant.
Yes, the magistrate's position.
Also because there wouldn't be anything for them to do.
No, but the staff, what I'm saying is the staff can be moved, but the magistrates, although their position will become redundant, they can't terminate their service because their service is protected also. But what would happen is that if they are not doing any work and they remain in the magistrate court, their terms and conditions of service would change because they won't get promoted, they won't get increases, so it would affect them in any way. Well, I have avoided looking into that because for entire magistrates to have to take the government to court on a matter like this, I would prefer to avoid that situation, avoid having to think about that. And because it would seem to me that a responsible government and a responsible legislature should look at this matter again, should reconsider it, and you're dealing with an important part of the state. The state functions in three arms: the judicial arm, the legislative arm, and the executive arm. And what signal a government would send to the public dealing with this, in which there is total and manifest unfairness to lower judiciary officers when they are appointed in order to do justice to people. I really didn't think of the legal options, and I prefer not to think of it.
Clearly, the objective, I'm not really sure the objective is
well, it could give that impression, but to me it is not. It's not going to have that effect. It seems as though it'll be it's running counter to the aims of dealing with the backlog. Now, it may be, if you were going to deal with the backlog, you wouldn't want new people with no experience to be appointed to become criminal court masters. You would take the people who you have there, and even if you have to have assessment, a procedure of assessment, but what you have done, you have not stated, as the Jamaicans have done, to have them transferred to perform those functions. And what can happen, some of these people who are very good and who have this experience, they will be absorbed in other countries. So it is an injustice to the country to lose that kind of human resource, quite apart from the personal difficulties of the individual magistrates. Okay?
So Maharaj,
yes, sir.
on the sitting of the court.
You always like to ask me some controversial question, anyhow.
No, once someone goes to court, civil case, judgment is made in that person's favor. How does that person, what's the procedure for receiving payment?
Okay. Let's say a judgment is given against Mr. A, and Mr. A is called upon to pay the money, and Mr. A does not pay. If Mr. A owns property, that property can be put up for sale. You call that the execution of the judgment. If he does not own money, the person can take out what is called a judgment summons in the High Court, and that person has to go to court, and that person will be examined, and the court will make an order that if that person doesn't pay by installments, because the court would examine the means, and even if the person is not working, the court can make an order for the person to pay a certain amount every week. And if the person doesn't pay, or every month, and if the person doesn't pay, there's a process that there can be an application for the person to go to prison to serve simple imprisonment.
No, I'm talking about where payment is made.
The payment.
Who receives the money? Does the lawyer receive the money?
Oh, sorry. If a person, let's say Mr. A gets a judgment against Mr. B, and let's say the lawyer is Mr. X, right? Normally what happens, the check is sent to the lawyer for the benefit of the client. But the lawyer has no right to take any part of that money unless it is a cost which has been ordered by the court. If the lawyer takes any part of that money, it comes as if the lawyer is stealing the money of the client.
So if the lawyer does not pass on the money to the client, what happens?
The client should go to the police.
So could the lawyer be charged with fraud?
Yeah. Yes, that is fraud. You have a similar case? All right. Okay. Okay, thank you very much. Because the lawyer holds the money in trust for the client.
Yes.